Welcome everyone to the second of a two-part symposium on cyber hate, defining and combating anti-Semitism and hate online. This second session, titled Combating Online Hate, Law, Technology, and Society, will examine remedies and responses to online hate. And we have an extremely esteemed panel of speakers. The format for today will be as follows. The symposium will start by a keynote by Yuval Shany, professor and former dean at the Hebrew University School of Law and former chair of the United Nations Human Rights Committee. He'll then be joined by our panel of experts to discuss the issues in greater depth. The panel includes Imran Ahmed from the Center for Countering Digital Hate, Professor Marianne Franks from the University of Miami School of Law, and Professor David Kaye from the UC Irvine School of Law and formerly the Special Rapporteur for Freedom of Expression at the United Nations. Before I introduce Yuval Shany, a few housekeeping issues. First, please look at the chat for the MCLE sign-up sheet. We'll also be posting a link in the chat to the MCLA Certificate of Attendance, and these are Google Docs. Second, note that this is the second of two sessions on the first session, Translating Hate in the Digital World, which defined the scope and problem of cyber hate and its manifestations, can be found on the session, our symposium page, and we're going to provide the link also in the chat. And now it's my pleasure to introduce Yuval Shany. Professor Yuval Shany is the Hirsch Lauterpacht Chair in International Law and the former Dean of the Faculty of Law at the Hebrew University of Jerusalem. Professor Shany directs the Cyber Law program at Hebrew University, the Fetterman Cyber Research Center, and is also the Vice President for Research at the Israel Democracy Institute and co-director of the International Law Forum at the Hebrew University Law Faculty. He served until recently as a member of the UN Human Rights Committee, and he was chair from 2018 to 2019. Thanks, Yuval, so much for being with us.
Thank you, Ken, for inviting me and for this kind introduction. I'm very grateful to be invited to speak at this very interesting symposium on defining and combating online hate speech. I've watched also the previous symposium in the series, which was excellent, and I hope that myself and the other panelists will be able to live up to the same standard. I'm quite certain, at least that the panelists would. Today's meeting is dedicated to legal, social, and technological remedies and responses, and I will focus on the ways, in my presentation, on the ways in which international human rights law can inform current evaluations and the future developments of anti-hate speech norms and procedures. The first point which I want to make is a rather obvious one, but one that needs repeating nonetheless, and that is that freedom of expression is a very important human right, but it is not an absolute human right. Even the United States, which has a very robust constitutional framework for protecting freedom of expression, the First Amendment and the jurisprudence which has developed that, interpreted that constitutional provision. Even under US law, there are some accepted limits on expression, for instance, when one is confronting an imminent risk of unlawful violence. But for most countries, actually, they go beyond that and establish additional criteria for circumstances that would justify certain limits on offensive speech. And the same approach and the same philosophy is also found in international human rights law, and specifically in Articles 19 and 20 of what is probably the most important international instrument that exists at the global level and that defines and protects the right to freedom of expression. And that is the International Covenant on Civil and Political Rights, which introduces in Articles 19 and 20 a balancing test, which distinguishes between three categories of speech. One would be protected speech, The second would be unprotected speech, which would be speech that governments may curtail for legitimate reasons in response to certain compelling state interest or in order to protect the rights of others, subject to certain conditions. And then there is a third category of outright impermissible speech. And hate speech and anti-Semitic speech would typically fall under this latter category if it meets the criteria of Article 20 of the Covenant, which prohibits advocacy of national, racial, or religious hatred that constitute incitement to discrimination, hostility, or violence. I would note that when the United States had ratified the ICCPR, it did enter a reservation to Article 20, the hate speech article, intended to ensure that it does not, that the United States does not accept any obligations that conflict with the Constitution and laws of the United States. And we will hear more of that in the panel, but I would say that the United States approach towards freedom of expression, which is indicated as a very broad and liberal approach, serves as a backdrop to some of the regulatory challenges of combating online hate speech, especially when that hate speech involves the conduct and practices of US-based technology companies. The second point which I want to make is also a rather rudimentary one, and that is that the hate speech discussion, debate engages the legal and ethical responsibility of private actors. And that includes individuals, the individuals who actually post, for instance, offensive messages on social media, but also, of course, the social media platforms that disseminate these messages. Now, unlike the US government, which is bound by the Constitution, the latter companies, the latter entities, they are not directly bound by the First Amendment in the sense that they are at liberty to adopt more stringent limits on expression in accordance with their terms of use or community standards. And in fact, the famous Section 230 of the Communications Decency Act, on which we will hear more at the panel stage, encourages, but does not compel companies, internet companies, to apply content moderation vis-a-vis objectionable conduct. But the question ultimately whether to do so and to what extent has remained up until recently a matter primarily of company policy, which is driven by ethical sensibilities, but also by economic considerations. Now, increasingly, this is not the case in other jurisdictions around the world, and in many cases, domestic laws that prohibit hate speech do not include an Article 230-like immunity. And to the contrary, in fact, the trend, at least in Europe, has been recently to pass legislation that imposes legal liability on online platforms that fail to promptly remove harmful contents after they have been alerted to the presence of such contents on their platforms. A leading example is the German Network Enforcement Act, the NetzDG from 2017, that requires the removal of manifestly unlawful content within 24 hours and other content prohibited by German criminal law within 7 days at the threat of massive fines directed at the companies going up to 50 million euros. France has passed last summer an even more stringent piece of legislation, although it has been partly set aside for the time being by the Constitutional Court for excessively limiting freedom of expression. The EU Draft Digital Services Act, which is a very important piece of legislation that is making its way through the processes of the European Union, does similarly require expeditious removal or disabling of access to illegal content as condition to immunity from liability while observing freedom of expression. So we are seeing a push on the part of certain jurisdictions on online platforms to increasingly regulate and increasingly limit and review their hate speech policies and procedures. And I would argue that these pressures do coincide with pressures coming from civil society. We have seen in the United States last year a strong push towards advertisement ban on Facebook in response to their hate speech policies, and also calls in the United States to set aside Section 230 immunity. This new climate, this new atmosphere, does lead certain companies, some of the leading companies such as Facebook and Twitter, to review and occasionally revise their policies on hate speech. We have seen Facebook recently revise, for instance, its policy on Holocaust denial. And we've also seen Twitter, for instance, revise its policy on the dissemination of what is called misleading information. Now, I would argue that in all of these cases, international human rights law does offer a useful framework for evaluating governmental intervention in both directions. On the one hand, insisting on states effectively outlawing hate speech and thus fulfilling what we call in human rights law positive obligations to protect individuals against attack on their personal safety, on their personal dignity, sometimes on the right to equality. But on the other hand, prohibiting governments from going too far and introducing excessive measures of censorship that represent unjustified limitations on freedom of expression. Now, this is, as you can imagine, this is a very delicate equilibrium, going far but not going too far. And I would argue that it actually is more complicated than seems at first glance if you factor in two additional elements. One is the idea that the Canadian Supreme Court has developed in Walcott case, which is that hate speech, the prohibition against hate speech can be justified not only on the basis of balancing between rights, but also because hate speech in itself stifles discourse and is therefore anathemic to the very values that protect freedom of expression. So hate speech actually stifles freedom of expression. It doesn't. It's not only something that has to be balanced against freedom of expression. And the second complicating factor is the chilling effect of regulation, that even if it does not kick in and actually introduce, for instance, fines on failure to remove contents, it does create an atmosphere in which companies, in the case of doubt, do err on the side of caution. And I think this is some of the criticism that has been directed against the German legislation and the French legislation, that even if it can be defended on its merits of the actual standards that the law introduces in terms of what is permissible and what is not permissible, it does create a climate which constitutes, which generates a chilling effect and does stifle freedom of expression. Now, this is a very complicated, very delicate topic, and I think the meta question that one should pose is, who should be the one undertaking this equilibrium? Who should be actually striking the balance between the different competing rights and interests? And the answer today is that the platforms are doing this, and this is, I think, an answer that is in itself troubling. And why am I saying that it is the platforms? Because if you look at Section 230, I mean, Section 230 does delegate it to the platforms to decide what standards they would want to follow. Essentially, in the European context, it is the platforms that are expected to balance, and even under the Digital Service Act, they would actually find ways to strike an equilibrium between the need to remove unlawful content, but respecting freedom of expression. They're actually getting very limited guidance from the regulators as to what exactly they should do. And we are seeing that the platforms themselves have increasingly assumed the responsibility to review, revise, and apply new rules on content moderation to meet the growing demand for a less toxic product, you can say. The problem, of course, is that there is a problem of legitimacy here as to what is the justification for delegating such an important decision about society and about the scope of what is permissible to express within public discourse to private companies. Now, for many years, the companies have actually shirked the role of the responsibility of being what they call arbiters of truth. And a lot of the Holocaust denial discourse was really about whether the companies have to, even in extreme cases, have to intervene and put their foot on the brake and distinguish between what is truth and what is lie, what is malicious intent, what is benign intent. And now, in a way, we are seeing the companies, the platforms being pushed and reluctantly assume the role of what David Kaye in his book called speech police, actually being the entity that is now responsible for freedom of expression in society. Now, we have seen an institutional manifestation of this new assumed responsibility in Facebook's new oversight board, which can be seen as an attempt to introduce some legitimacy for the heavy responsibility of regulating online speech that Facebook is assuming by introducing the review of borderline decisions by an independent body of and diverse body of prominent individuals. I think the idea being that this review process could generate some deference for platform decisions from the public and national regulators. And I think it remains, the jury's certainly out on whether this effort of legitimizing regulatory choices in this field will succeed. I would say that the first decisions, we have already seen the first batches of decisions by the oversight board. And I think there are some elements which are quite impressive. And I would note in particular the reliance by the oversight board, the explicit reliance on international human rights law as a benchmark for issuing the decision. And I think it is also important that the board has not only satisfied itself by reviewing the specific posts or messages that were removed, but actually making some policy recommendations for Facebook to embrace, mostly with regard to greater clarity in the rules governing online hate speech and other prohibited other regulatory choices, as well as increased transparency. However, it is also notable that for the time being, the board is only allowed to review decisions to take down content. It is not authorized for the time being to review decisions not to take down content. So in a way, if we are concerned about the prevalence of hate speech on online platforms, the operation of the board only works to tilt the balance in the direction of greater protection for freedom of expression and not in the other direction. I would also say that the whole model that has been developed, the whole oversight board model, does have, I mean, we should be realistic about what it can actually do. I mean, it does review ultimately what is a drop in the ocean in terms of content moderation decisions that the platforms are taking. It reviews, I should say, of course, only the decisions taken by one platform, a handful of cases every year out of millions and millions of postings, including many thousands of very controversial postings. It reviews borderline cases. It does not review the policies themselves directly, only maybe indirectly. Because it is entrusted with reviewing the application of policies and values of the company, but not review the policies themselves. It does not look closely at the procedures for submitting and handling complaints, and it ultimately focuses on one aspect, which is removal of contents, and not other very important decisions, policy decisions that perhaps are even more important to delineate the space for freedom of expression, on which I will perhaps elaborate momentarily. Let me say something about what are these standards? What do these standards actually practiced by online platforms look like? And let me, in the interest of time, let me focus on Facebook mostly, because this is perhaps the most sophisticated and the most dynamic of the large platforms in reviewing community standards on hate speech. And I think when you review the community standards on hate speech by Facebook, I think there are some very positive elements, but there are also some very significant gaps. So what I can say about this is that it is over-inclusive in some ways, it is under-inclusive in other ways. What one can safely say that the definitions that Facebook is using are not based on international legal standards. and do not resemble hate speech laws that you find in many jurisdictions, but rather they are centered on a quite specific understanding of what is hate speech, defined as direct attack against people on the basis of what we call protected characteristics. And I would argue that it is centered on the notion of direct attack on members of a group, but not on harm to victims, which could be something that could emanate from indirect attacks or on attacks against individuals that belong to groups that Facebook does not consider to be protected groups, such as, for instance, members of a political movement. There are also problems relating to the different silos in which the policy is divided into, whereas in actuality, the silos often cross one another. So the hate speech silo and the violence silo and the disinformation silo often interact with one another in ways which are not fully captured by the rules. So I would argue that the over-inclusive nature of the rules, as we can see by the intervention of the Oversight Board, and the simultaneous under-inclusiveness of the rules, that does imply that the choice that we are seeing in the application of the rules is not necessarily in the development of the rules and in their application is not necessarily a choice between freedom of expression and censorship, but between one set of standards to strike the balance between the two and another set of balance. So and that may have to do with the algorithmic-like nature of community standards as they are formulated, that would allow mechanic application either by AI or by content moderators or cleaners, but would often lead to missing the bigger picture of what is the harm that is intended and what is the harm that is caused. So we are left in a situation where you have these powerful online platforms determining their own rules as they go, and through that our own speech ecosystem with limited accountability and limited transparency, but also at this point in time, limited capacity to effectively enforce their own standards. And this we can return to maybe in the Q&A. We do see still on platforms very troubling forms of speech, which most or many experts would designate as hate speech, but would fall between the cracks of the existing policies. Now, I want to, moving towards the end of my presentation, I do want to underscore the falseness of what I consider to be the falseness of the choice between freedom of expression and censorship in introducing human rights standards to reviewing policy community standards by online platforms in two other dimensions. One is the binary choice between which seems to dominate the discourse on content moderation, and that is the question of to remove or not to remove, or to platform or to deplatform. Whereas I would argue that one could introduce a more nuanced and address some of the concerns about hate speech or offensive speech or borderline speech through more nuanced ways than simply deciding whether to remove or not. For instance, there are questions relating to virality of contents and policies relating to accelerating or slowing down virality. There are questions relating to the efforts that are introduced by online platforms to draw attention of users to community standards. There are questions relating to the use of counter messaging. And the claim is that all of these nuanced measures can introduce some harm mitigation strategies and measures without actually overly restricting freedom of expression. So in a way, we need to expand the discourse, both with regard to the policies, the contents of the policies, but also with regard to the remedies that are being offered. Now, I would argue even at a more systematic level that some of the exceptional risks that are associated with online hate speech, and that the famous concerns about scale, scope, and speed that arguably justifies a greater degree of scrutiny of policies in this field than in other offline fields. These are not neutral or inevitable features of the online environment. These are the result of policy choices. And a colleague of mine from the Federman Center, Tomer Shadmi, who has written this specifically with regard to disinformation, but I would argue that similar claims could also apply and should also apply vis-a-vis the application of hate speech or hate contents. And the argument is that the use of algorithms for assigning virality on the basis of certain traffic features, the use of personalization of contents, the use of filter bubbles, and even the design and layout of platforms so as to muddle up legitimate trusted sources with the less trusted sources. These are the causes of much of the harm that is generated by speech, being it hate speech or disinformation, and that these architectural features, which are part of the business model, are really not an intrinsic part of the user's freedom of expression. They may be part of maybe the platform's freedom of expression to the degree that we acknowledge one, but I think we can address them, these features, without overly limiting the freedom of expression of users. So in a way, introducing these architectural features into the debate could also help us create an environment which is more sensitive both to freedom of expression, but also the harms caused by online hate speech. Just closing down, I would like to draw the attention of participants in the seminar to a project which I undertook as part of my work at the Israel Democracy Institute with also Yad Vashem, which is the Israel's Holocaust Memorial Institution. And David Kaye here has consulted to this project, along with some other experts. And we have developed in 2019 a policy document which focuses on reducing the online hate speech phenomenon and contains 16 specific recommendations which we believe platforms should consider to adopt, and regulators of platforms should also consider consulting. And I would not go over the 16 recommendations, but essentially I would say that the main recommendations that we made in this document and in the research that underlay it were that first, social media companies are legally and ethically responsible for harm. Secondly, that the definitions of what should constitute hate speech should be adjusted to meet international human rights standards and criteria. That the regulation of hate speech should also include nuanced remedies, including preemptive interventions when necessary, that complaint procedures should become more accessible and independent, and that companies should engage in a broader process of consultation about the standards themselves. Now, these recommendations are not a panacea for the challenge of defining and combating anti-Semitism or other hate crime, but I would humbly submit that they would mark a step forward and could help formulate more appropriate anti-hate speech policies. So I will conclude my remarks here, and I thank you for your attention. And now I would invite the panelists to light up their cameras and join me in this conversation. So I would like to welcome Imran Ahmed and Marianne Franks and David Kaye. So thank you for joining me, colleagues. And the way we will do this is that I will pose each one of you an initial question, and I would ask you to briefly introduce yourself, and then take 5 to 7 minutes to respond to the question. You do not have to use all the time allocated, because we would want to do a couple of rounds and then open it up for Q&A. So for you, Imran, the question that I pose is, How do you see the scope, the scale and nature of this problem that we are dealing with? And to what extent, how does the nature of the problem affect the way we should be dealing with it? So what do you see is the connection between the problem and the remedy to the problem?
My name is Imran Ahmed. I'm Chief Executive of the Center for Countering, which is a US, unsurprisingly, with my organization seeks to disrupt the production and distribution of hate and misinformation. Advisedly. So there are different lenses through which you can see the problem of anti-Semitism. You could take a anthropological view as to why it is that anti-Semitism is so compelling as a solution to as something that explains the world. Evil Jews who are seeking to do X, Y. You can videos cutting. Apparently, if you'd like, I could switch and pop back in shortly. So how about you just move on and I'll come back.
Yes. So yeah, I mean, you're coming a bit staggered. So let me switch to Marianne, okay? And Marianne, I mean, can you please comment on the legal environment, and how do you think the legal environment, to what extent is the legal environment in which online platforms operate, creates incentives or disincentives for addressing the hate speech problem?
Hi, everyone. I'm Marianne Franks, and I'm a professor of law at the University of Miami School of Law. And I'm also the president and the legislative and tech policy director of a nonprofit organization called the Cyber Civil Rights Initiative, which focuses on protecting the civil rights and liberties of especially vulnerable communities against threats coming from technology. And so what I spend a lot of time thinking about is exactly this question that Yuval has asked, which is, what's constraining platforms right now in terms of being better at innovating around these issues around free speech and hate speech? And I ask it this way because I think it's sometimes easy to forget that as non-government actors that have nonetheless all this incredible influence over all of our lives, these private entities could be taking any number of approaches that would push back against, or at least complicate the picture of that false binary that you've all mentioned, which is free speech versus censorship. We could, for instance, be thinking very hard about how is it that we can achieve this goal of freedom of speech for more people, as opposed to thinking there's a lot of speech, we've got to keep the status quo, and any regulation means less speech and therefore is presumptively negative in some ways. Why not let the question be, what are the conditions under which most people or more people would actually feel free to speak? And if we looked at that question, we already have all this empirical research that shows that when people have to fear that they will be targeted for a coordinated hateful campaign, when they will be threatened, when their private information will be exposed to the public, they will be much less likely to speak. So that we can think about speech in this much more nuanced way as, what are the conditions people need in order to speak freely? And what can platforms do to actually encourage that? Now, the problem, as I see it, is that so much of what is determined for the major platforms right now, that is Facebook, Google, Twitter, is that they are operating very much within what I sometimes call a First Amendment shadow. That is, that the United States approach to freedom of speech is incredibly, in my view, naive. It's very simplistic. It takes a view that there's speech versus other things, speech versus privacy, speech versus security, and that everything that limits speech, we have to justify in terms of some kind of trade-off, as opposed to imagining a view of speech or conceding that speech is actually embedded within rights to privacy and rights to dignity. So that's a problem. It shouldn't be as much of a problem as it is, because as Americans are supposed to be aware, the First Amendment doesn't apply to private platforms. It's only a restriction of what the government can do. But instead, what you found, because so many of these companies were founded by Americans who seem to be trapped, at least their imaginations seem to be constrained by this view of speech as a binary. There's speech, and then there's regulating speech and censorship. And that they feel that they have to track the First Amendment in some ways. So regardless of what one thinks about the First Amendment regime, and I think there's a lot of reason to criticize it, it's even worse in some ways, or at least it's less interesting that we would adopt those same constrained views when we're talking about private platforms that have the freedom to do any number of other things to think about speech differently. So I think what you've got here in particular is an overlay of the First Amendment being incredibly speech protective in this really shallow sense. More speech is better without asking about the quality or who's even speaking. On top of that, as you've all mentioned, you've got Section 230 effectively telling platforms the way to protect freedom of speech is to keep everything up. Now, if you want to take some things down and you feel like doing it, that's great, but you don't have to. You don't have to have any kinds of difficult conversations among yourselves about how it is that you could most adequately protect freedom of speech for more people. And you don't even have to care if you are actively facilitating and profiting from speech that silences other people. You don't have to worry about it. If you feel like it, you can, but you don't have to. So that's where the legal regime has really, in some ways, really benefited the tech community, that is, gotten them off the hook because they just don't have any incentives to really do anything that cuts against their bottom line. But it's also tragic in the sense that it's limited their sense of what they can do. And I say that as someone who has worked on trust and safety councils and been an advisor to these companies, literally in terms of what they can see, has been constrained by this idea that leaving speech up is somehow protective of free speech and regulating speech in some ways is somehow not, as opposed to thinking about all the complex ways that speech actually operates, including in things like design structures that Twitter doesn't think of limiting you to 280 characters as censorship, but of course it is. If you want to have that incredibly capacious view of what censorship is, there are ways to boost certain types of behavior. There are ways to disincentivize other kinds. There are ways of watching your users game certain systems and realizing that you can shift policy so that they don't do that anymore. And there simply isn't enough of an incentive for these platforms to do that kind of creative thinking and take some sort of good use of this vast amount of access that they have to people's behaviors. It is not a great situation that we live in a world where we're so dominated in our thoughts and our conduct by these platforms. But so long as that's going to be true, it would at least be less bad of a situation if those companies could think about using their power for good. There are so many different ways that they could be incentivizing different kinds of speech, disincentivizing certain forms of chilling speech, and actually trying to serve the goal of a speech ecosystem where diversity can flourish. And they're simply not doing it now because they have no legal obligation to do so. So I have more thoughts that I could share about that, but I'll stop there.
Thank you, Marianne. That was very interesting. I want to go back to you, Imran. I hope your connectivity is better now and let you complete your thread, and then we'll go to Dave.
Thanks. Sorry about earlier. Really, it helps having Mary having spoken just now, because I think she brought up a lot of questions that I hope to address myself, which are that the production and distribution of anti-Semitic content, of misinformation about vaccines, about COVID, about a huge array of issues that CCDH looks at, is profitable. And it's become profitable because we have tolerated the fact that people are willing to produce this misinformation, promote this misinformation on social media, and then host the and host the misinformation in perpetuity. So in terms of the economic incentives for social media companies, they are the primary locus for this kind of discourse. And it's any attention and any market in which they can dominate is really, really important to them, because they know that they can profit from any traffic that's generated by by anti-Semitism or other forms of misinformation. the economic incentives are there for them to create those communities, because if they can host those communities, they can profit from them. The incentives are there in terms of when it comes to conspiracism. If you were trying to find conspiracism about Jews, and frankly, like when I do talk about anti-vax misinformation, there is often anti-Semitic elements or undertones or tinges to it. Again, the main place you find that stuff is in Facebook groups, on YouTube, on spaces that are very, very familiar to us. And the platforms have played a very canny game in navigating, with a degree of sophistry between the lines of what's law, what's custom, what's the First Amendment protecting. They've deployed all sorts of, it's fairly weak arguments. I mean, they've both argued that they are subject to the First Amendment or that they need to protect freedom of speech. But at the same time, if you go and look at their the stuff their lawyers have argued in courts, they've argued several times that they're not subject to the First Amendment as a private platform. And what they've done is they've managed to obfuscate as much as possible their moral responsibility. So, I mean, this session is about the technological and the legal aspects of anti-Semitism. But to me, underpinning all of it is a series of simple moral questions. Should you profit from the production and distribution of anti-Semitism? If you do so, are you complicit in the worsening of anti-Semitism in our world? Could it be argued that social media, which we know, the Great Replacement Theory, which is a classic example of an internet-generated hybridization of multiple different types of identity-based hate and conspiracies, if your platform was instrumental in the creation and in the hybridization of those conspiracies, the creation of a new master theory, are you responsible for the loss of lives in both Christchurch and Pennsylvania? And those questions we simply haven't asked. We seem to ask, does this meet a pre-existing standard for what we consider to be intolerable? It should surely be intolerable for you to be profiting from the traffic generated by this malignant content. And not just that, but malignant content produced by a relatively small subsection of actors who happen to be very good at generating high attention content. So the platforms benefit both from the attention that's brought there and, something that they continue to encourage. And we've got a report coming out next week that I really shouldn't talk about because it's coming out on Tuesday and I'm kind of ruining the report launch now. But the report also, what we've been studying is what do not just what do they have on their platforms. And I've taken anti-Semitic content to executives at Facebook and asked them, does this meet your standards of hate speech? And they've said, we'll need to go and look at it. And there were literally pictures of Hitler saying the real thing and pictures of Barack Obama with a Star of David shaking hands with Netanyahu with a cloven hoof. And they told me we need to go and think about it. And they wouldn't remove the groups until we then decided to take things to the next step, which is that we expose it through the press. And CCDH's most prominent work is the stuff we do publicly. I can promise you that's a tiny subsection. That's the stuff that we know that if we show people, they would immediately remove it because they wouldn't want to be seen to be morally culpable for hosting that content. But there is also the fact that the core logic that underpins their systems understands that conspiracism and hate are really, really good ways to keep people's attention, because not just the people who like the hate, but people who hate the hate engage with it and therefore drag themselves in, allow themselves to use the platform and therefore give opportunities for the serving up of ads. And the report that we've got coming out next Tuesday shows how when people on Instagram in August 2020, the same month that Mark Zuckerberg became a centibillionaire, by 5 cents after 5 cents of ads being served to people consuming the content that other people produced and put on his platform. In August 2020, Instagram was Facebookized. So they launched a machine learning algorithm that instead of getting to the bottom of your feed and it said, there's nothing more to read, they started saying, well, here's some stuff that you should read. We found that algorithm was feeding anti-Semitism that people weren't following into their feeds if they were already following other types of conspiracy theory. So either the algorithm recognizes the fact that people tend to rabbit hole because conspiracism and hatred, they are correlated with epistemic anxiety, but they don't sate that epistemic anxiety. So people rabbit hole down lots and lots of different routes, and hyperlinks allow them to sort of to go and keep doing so with zero effort. And the algorithm either recognizes that people do that, but it's also encouraging them to do so. So they have produced an industry that is worsening the crisis that we have in the world of what Harry Frankfurt called bullshit, that the absolutely indistinguishable sea of information and misinformation that we now swim in. Our entire sort of epistemic existence is now digital in nature. I've just moved to Washington, DC 6 months ago. I brought me only one book because who needs books? You Google, right? Or you go and check on your Kindle. I mean, I very rarely even look at my Kindle anymore. I just Google stuff because I don't have the time to read a full book. So the big issue is that the entire architecture by which we perceive the world is run by those algorithms. And those algorithms suck because they're only there to keep our attention, to make us angry or curious about the latest bit of misinformation and profiting a private company. This is not a question about international law necessarily between states. This is a question about why have we allowed people to make their money from hosting, producing, and distributing anti-Semitism.
Imran, I want to go to David. Can you
I'm done. That's it.
We'll have a second round. So I mean, this was very distressing, but I really want to. Do you hear me well? Okay. Am I back? Am I frozen? Okay, good. I really want to pick. You actually mentioned about international law and companies, okay? Because this is something that also Marianne made the point about the First Amendment not applying to companies. And you made point about international law not applying to companies. And I also hinted to that. So David, you went around the world as special rapporteur advocating freedom of expression to states, but what do we do with the companies? This is indeed a big question. What do you do with international human rights law and the companies? Is there a way by which you could actually superimpose these standards on companies?
Yeah, Yuval, thanks so much. So I'm David Kaye. I teach law at the University of California at Irvine, and I was the UN's Special Rapporteur for Freedom of Opinion and Expression for about 6 years. And in that role, I monitored free speech issues around the world. And of course, the big speech issues of the last several years have focused on online speech and sort of the digital transformation of communications. But I don't want to start there. I agree with so much of what Marianne said, and the points that I want to draw from are really drawn very much from sort of taking off from where she ended, and also, taking advantage of the problems that Imran mentioned and the framework that you put out there for us, Yuval, in your really brilliant overview to start us off. So I completely share Marianne's points about a digital environment, certainly a private platform environment that is marinated deeply in the First Amendment, and that kind of marination, and I won't pursue that metaphor any longer, has really made it difficult for the platforms to deal with exactly what I think all three of you have already talked about, which is the nature of online harms and online behavior that is designed to silence voices, designed to interfere with privacy, and also, frankly, designed to generate offline harms. And the reason why the First Amendment, I really don't want to repeat what Marianne said so brilliantly, but the First Amendment is so speaker oriented. And what I want to suggest is that, and something that I sort of had been suggesting in part out of professional duty for 6 years, is that governments and companies should be actually implementing what they already have in a framework of human rights law obligations, which actually brings the nuance that you're all talking about and allows us to see speech as not only what a speaker imparts, but also what individuals have access to. And it also allows us, I think, to see the sort of the competition that we're all kind of talking about around speakers and audiences and so forth, not as a question of balancing. I mean, I really reject the idea of balancing, because balancing, in my experience, almost always results in the censor having the greater power here, or the speaker having the greater power. I think what human rights law provides for us is a way to see that whoever, whether it's a public authority or a private authority, is aiming to restrict speech, is doing so, is demonstrating that they're doing so on appropriate grounds. And the reason why human rights law, and so let me just, I'll say 2 points here in the next few minutes and then close up. Human rights law first begins with obligations on states, right? And it starts with the recognition that everyone enjoys the right to seek, receive, and impart information and ideas of all kinds, regardless of frontiers and through any media. It's a robust statement of freedom of expression that goes well beyond, you know, simply the Congress shall make no law language that we have in the First Amendment. It's robust, but it also says that states, and this is all in Article 19 of the International Covenant on Civil and Political Rights, it also says that states may restrict expression when they meet 3 criteria, 3 conditions. So one is the criteria of legality. That means laws that are clear enough, that are do not provide excessive discretion to the authority to decide, you know, willy-nilly what kind of content should be up or down. Secondly, the condition is that it should be necessary. So any restriction should be necessary. And third, to protect a legitimate interest. And what are those legitimate interests? Legitimate interest may be the rights of others. So privacy, the right to personal autonomy, the right to voice, another person's right to freedom of expression, national security and public order. So you could think about the way in which speech sometimes causes offline harms, as we saw on January 6th in the United States. And also it could be on grounds of public health and public morals, which are broad statements. Public health, you know, we can certainly see that in the context of the past year and pandemic restrictions. So those are standards that apply to states. What I would argue is that those same kinds of standards should be applied by the companies as well. And they should apply them by recognizing that they have responsibilities generally, but also under the UN's guiding principles on business and human rights, a framework for business responsibility that was adopted by the Human Rights Council or endorsed by the Human Rights Council in 2012. And that set of standards basically says to the companies, one, you should have human rights policies, right? If you are going to have an impact on the rights of the community, the rights of others, if you're going to have any kind of human rights impact, you need to have a policy to deal with that. So that means starting at the kind of highest level with a standard for your behavior aiming towards the prevention or the mitigation of human rights harms. We rarely talk about this. The companies, generally speaking, do not have human rights policies, and they should. The second part is that they should have transparency. And I think we probably all agree that there are few companies as opaque as social media and search and other actors in the internet environment. They're extremely closed. And so we have a real difficulty. So when Imran's talking about the amplification and the algorithmic decision-making that we see happen on the platforms, it's very hard for outsiders to engage with that because the companies are simply not providing, you know, the details. And I'm not saying provide the code, but they're not providing basically the structure of their decision-making in a way that either could be evaluated by researchers and scholars or could be available to policymakers. And so we're left in this environment where we have very little knowledge about what's happening inside. And then finally, although there's much more in the guiding principles that we could talk about, they call for remedy. And so when we think about remedy right now, if you're an individual who is subject to harassment on the platform, first off, it's very difficult to get access to the platform, regardless of the existence of an oversight board or something of that nature. It's very hard for the regular individual who's suffering from either doxing or stalking or any other form of trolling and harassment. It's hard for them to get access to the platform to even say, look, I'm reporting this. Why aren't you taking action in order to protect me from this misogynistic or anti-Semitic or Islamophobic or you name it kind of harassment? So there need to be mechanisms that the platforms have to actually provide remedy in that situation. I totally agree with you, Yuval. There should be nuance around what those remedies should be. It's not just a take down, leave up binary. There's other tools out there. There's also tools of design that Marianne and Imran, I think, really highlighted as well, which is giving people more control of their information environment, essentially. And I think, and I'll just wrap it up here because I've talked too long, that can all be drawn from a way of thinking about company and government responsibility that is drawn from the obligations both already have, at least states have, and companies should observe around human rights law.
Thank you, David. I mean, thank all panelists for a very interesting and thought-provoking round. Let's do it, because it was so good, we'll do another round, but this time a shorter round. And I would try to encourage all three of you to, and then we'll take some questions from the Q&A. I want to encourage you, all of you, to think about what should we be doing as a practical matter in order to change the incentives. I mean, Imran, you talked about the business incentives. Marianne, you talked about the legal incentives. David, you basically said, well, there is this, there are these standards, but they are not being applied. So how do you actually get them applied? So what should we be thinking of doing as a practical matter in order to disrupt the equilibrium, which we are, all of us are not happy with? So maybe Imran, you can go first.
So, I mean, one of the reasons CCDH was set up was because we felt that governments were too slow to understand, let alone to legislate to deal with the harms being created online, harms that at that point had taken lives in the UK, had taken lives around the world, and were threatening to see greater authoritarianism breaking apart of the sort of liberal democratic order. And we saw that in the UK, anti-Semitism in the party that I used to work for, the Labour Party, the Brexit movement and identity-based hate, the murder of my colleague Joe Cox MP. I mean, you know, blood had been spilled, and yet there was a certain bloodlessness about the legal debate about what we can do about it. And I mean, we started called Operation Yente as a project because I went to see Fiddler. I came out, my friend who's a contrarian said to me, Yente, she's a thing, isn't she? She's always gossiping. And I was like, but gossips make society because gossips make the private public. And actually, it's a bit of old-fashioned opprobrium that we needed. We realized we need to expose what's happening. And in doing so, expose in a focused way that drives change. And what we realized was that by starting to highlight the harms with the right stakeholders, whether it's the public or it's legislators or others, we could drive change because the companies have been gaslighting us by telling us this is about the legal restrictions placed on them. They have the right to make these decisions. They make censorship decisions all the time. They've just told us now, a year late, that they're going to censor anti-vaccine content. They're going to censor anti-mask content. They're going to get rid of not just anti-Semitism, but the precursors of anti-Semitism. And they told us that, and I wrote a letter to them the day before Holocaust Memorial Day saying, I've just searched for Holohoax, I can still find it. On Holocaust Memorial Day, the search Holohoax, they'd suspended the search term. So it said, sorry, you're not allowed to search for this term anymore. There's still lots of content, but they suspended the ability to search for it. I mean, these are companies that set precedent all the time as to what they're capable of doing. And my suggestion is that we should look beyond the legal. We should look to other tools, whether it be old-fashioned opprobrium. It should be not doing business with people who facilitate or produce malignant content. And facilitating the distribution of malignant content is a terrible thing. If you look at the Stop Hate for Profit Coalition, which we worked on with Sacha Baron Cohen and others, that was a good example of creating an economic consequence for the toleration of hatred on your platform. So there are lots and lots of tools that we have available to us. We need to start being a bit more swashbuckling in our responses in society, and as governments, as states, as individuals, as to how we think about what we can do to make Facebook realize, very simple thing. If you know someone that works for a social media company, bring them up today and tell them, do you realize how evil your company is sometimes? And just list off a list of the terrible things they do. You know, a little bit of old-fashioned moral pressure is a good thing. That's me.
Thank you, Imran. Marianne, what do you say?
I think it's tremendous to be pushing on this whole realm of action that these companies could be taking that don't rely on legal responsibility, because Imran is exactly right. No one should congratulate themselves when they've made it through a day not actually murdering someone or having directly done something that they could be so clearly in violation of the law for. But so releasing that kind of restraint on the imagination, and also stop using it as an excuse, as Imran said, that for years, these companies have been trying to say that they can't do certain things. And then it turns out they can, and they're wondering why they're getting criticized for, from what seems like all sides, but it's partly because they created the myth that they couldn't do anything, which has always been a lie. There isn't a single platform out there, whether it's Facebook or Reddit or 4chan or any of them, that doesn't have rules about spam, about behavior that's prohibited on the platform. They all have rules, all of them. So there's that. But this, I think, ultimately is a question of human behavior. Are you going to be able to get people to care about being better if they don't have to? And when I say have to, what's going to be the actual negative consequence if they choose not to be good people and not to be good companies? And so I hate having to rely on the law for this, but it seems like the bare minimum that we have to have. People don't change their behavior unless they face consequences for not doing, for engaging in that behavior. So I come back to the Section 230 problem, because I do think it's at the heart of so much of this. Because if what you're trying to do is to make sure that people, and companies more so than people, right? Because the moral hazard problem only gets worse when you are a corporation. That is, if you're allowed to take risky actions and you never have to absorb the cost of those risky actions, you can just keep taking the money from it, and other people have to deal with the harm and the injury, you're just going to keep doing it, especially if you're a corporation who feels completely distant from those decisions that are being made. So what we have to do is to take away that sense of immunity, and that sense of immunity is coded into Section 230, at least the way that it's been interpreted, to tell most of these platforms that they're not responsible. And so we don't have that minimum standard of saying you might get in trouble for this, that I think would kick off all the other things that we might want them to do. And so when it comes to that question of Section 230 reform, we can talk about a lot of the technicalities there, but what I really think is at the heart of it is the dangerous attitude that has flourished because of the ways that we now live online, the dangerous attitude that there's no such thing as collective responsibility. The idea being that if you're not the person who pulled the trigger, you're not responsible for a crime. The perfectly common sense intuition that I think most people have in the offline world is that even if you didn't mean to, you can be responsible for lots of things. If you are a hotel that knows that sexual assaults are happening in your parking lot because you don't have proper lighting or a security guard, at a certain point, you can be held responsible. It's not because you wanted that to happen. It's not because you are deliberately hoping that it happens. It's because you didn't bother to take the most reasonable, easy step to prevent a foreseeable harm. At some point, that becomes your problem. So what we need, I think, is a reinvigoration of those norms that most of us, I think, really understand. You can be responsible for something even if you are not the last cause that caused it. And what is the problem, I think, with the kind of tyrannical hold that Section 230 has on companies is that it's also got a hold on our mindsets, which is that it's no one's fault except for the last person. So we need a Section 230 reform that actually pierces that immunity to say sometimes you companies are going to have to pay for what you've done or not done, because nothing gets people to fall in line quicker than the fact that they might actually have to change their behavior, pay some money, allocate some resources. We're going to need that as a minimum standard before they're going to do anything else. That's where I come down.
Great. Now, and to you, David, how do you apply this logic on a global stage?
Yeah, so I mean, I actually would like to, maybe as we discuss this further, talk about what, like how we do Section 230 reform, because I imagine there are people out there who are going to respond by wondering where we draw lines in a way that is consistent with whether it's First Amendment or human rights values. And I think that's a really important debate to have, because that gets really to the crux of how we move forward. But I want to suggest two different possibilities for dealing with the harms that we're talking about online: hate speech, misogyny, etc. The first is, I think, regulation that forces the companies to be transparent. I mean, I think that, and we could imagine the kind of transparency obligations that would involve disclosures of their rules, disclosure of essentially their case law, the way in which they make the decisions. I think there's this broadly held understanding or sense that the companies respond to public pressure, they respond to political actors, they're highly politicized, and they don't always deal with similar kinds of cases in a similar way. But we don't really know, because they're not transparent about their decision making. So I think that would be one step, a kind of regulatory environment that that actually forces them to be clear about what they're doing. And I think that could perhaps go to helping the kind of approach that Imran was talking about, which is a kind of public shaming process, which, if we know more, there's going to be more to shame about. The other part, I think, is a kind of public-private oversight that we need. We have no oversight right now. I mean, I have to admit that I'm concerned about government, whether it's the United States or Europe, and Europe is further along on the regulatory discussion than the US. I mean, the US often looks like a clown car compared to, the European process, at least in Brussels right now, but because it's so politicized in the US. But I think that there's room for basically pushing the companies to engage with civil society in particular, to develop cross-industry oversight that allows for remedy, that allows for grievance processes, that allows for, in a way similar to the oversight board, but in a much broader sort of way, a way that gets across the industry and doesn't focus only on this kind of independent company created model of self-regulation. And that might at least give us those two things together, both the insight into what the companies are doing and a kind of oversight that puts demands on the companies in more concrete ways than we see right now.
Okay, great. Thanks to all of you. I mean, we have about 20 minutes to engage with Q&A. We have many questions. So the way I'm going to do it, I'm going to read two questions, two at a time, and then each of you who wants to respond is more than welcome. The first question I have is about AI, artificial intelligence, and the role of AI in policing hate speech. So the question is whether we have a technology that is sufficiently advanced and accurate, and whether it is sufficiently informed by legal considerations. This is one question about the role of AI in this in getting us out of the mud, so to speak. And secondly, there is a question about vulnerable populations, especially minors and children, and whether we can identify best practices that offer safeguards for these individuals, and whether there is a certain legal requirement for companies to apply such safeguards vis-a-vis vulnerable populations. So any of the three who wants to take the dive, you're welcome.
Maybe I'll say something just about the AI part of the question, or the AI question. So AI can't do this work. I mean, it can, and we should step back a little bit, because the reason why we are so focused on AI as part of the solution is one, the companies, and if we're talking at least about the biggest of the companies, they're so massive, they deal with such a fire hose of information per minute that they need tools in order to sift through what they think of as content that is in violation of their rules. And they've promoted AI as a mechanism, but AI is notoriously bad at understanding natural language. It's good at imagery, it tends to be good at video, but it's not good at the kind of coded harassment that often gets through those filters, or that is maybe reporting or the calling out of bad behavior, and that stuff gets taken down. So AI is going to have a role. I think but it can't have the kind of role that we might expect or want it to have, which is to serve as a kind of, judge and jury of content. I don't think the technology is there, but what it suggests, I think, is that the companies, due to their size, need to be investing much, much more than they do right now in getting closer to their users. And right now, when we think about a platform like Facebook, more than 90% of its user base is outside the United States. Most of the content on Facebook it's not in English, and it might be content that involves harassment in a small town in the middle of a country where maybe the market isn't so big for Facebook, so they don't pay a lot of attention to it. We need to figure out ways to actually get not just the AI to work, because that's kind of a fool's errand in a lot of respects. We need to find ways to get the companies to devote the resources to actually getting close to their users. And instead of thinking of all of this just as a competition policy breaking up the companies, we might think of breaking them down, getting them closer to the places where there's actual harm. Great.
Imran, do you want to take a jab at the children, or also the AI?
I mean, I'm afraid that there aren't terribly good best practices around the world on safeguarding, and all the models that have been tried, whether it's the sort of common sense media approach in the US, or censorship, or age verification. I mean, they're tools, but they don't help the fact that you can easily get around those and produce content that has the aim of radicalizing people and feeding them anti-Semitism. I mean, I always say one of the most brilliant bits of liberal propaganda I've ever seen is Paddington, the movie. I walked out of it and there was this 11-year-old kid ahead of me who was crying and saying, but he just wanted a home. And I thought, brilliant, that's another liberal for you. But I mean, it's very difficult, therefore, to work out from speech what the intention is using natural speech analysis or artificial intelligence. I mean, they say artificial intelligence. I can find you, and if you haven't banned holohoax, how intelligent is your artificial intelligence? I mean, it's pretty stupid, right? But I think that human beings are very capable of passing through and working out about what speech is bad and what isn't, and more importantly, which actors are bad and which aren't. I mean, if you're, the thing about a sea of anti-Semitic bullshit is that you've got to go for the producers of the bullshit. And who's actually doing that? It's a relatively containable set of actors. And they're still given platforms. They're still allowed to abuse the terms of service every day. There are rules on those platforms. You're not allowed to produce them. Those responsibilities that we all observe as users are not rights that are observed by, they're not rights that we are afforded to us. So we follow the rules. We don't put up misinformation. We don't put up identity-based hate. Surely we should therefore have a corollary right to a platform that's free of that misinformation and hate, and yet we don't. And that's because it's not about the technology, it's about the will to act. It's about the will to actually take action when bad things happen.
Thanks, great. Marianne, do you want to add something on this, or should we go to the next one?
Just really quickly, just to reinforce what's been said, that the AI question in so many ways is fraught because AI is nothing more than people at the bottom of it, right? So if we can't get people to make decisions that will scale. If we can't get people to understand that there are certain types of speech that, you know, are maybe not ideal for a free speech environment, we're never going to get anywhere. The question about vulnerable communities and minors is that we've seen, at least in the United States, the reason why they've all failed is because the court has said, look, anything that you would do to restrict to vulnerable communities is also going to basically baby-proof the world. And so we can't have that. We have to think of our ideal user as an adult and then try to, you know, do things at the margins to protect others. And the thing about the internet is it just doesn't work like that. And so we're going to always face that kind of tension of who should the universal subject be? Should we imagine it as an adult person with certain characteristics, or should we imagine vulnerabilities that can be exploited? And that's going to set the agenda for much of the work that we do in that space.
Okay, great. So the next couple of questions are as follows. First, on data as profit. I mean, so we have a question about the data as profit business model that is driving the business model of social media companies. And the question is whether is there a methodology for quantifying these profits? I guess this is a question which is looking at this from a legal restitution point of view. I mean, could we evaluate what is the business market for what is the market value of this business model, which Imran, I think you alluded to. And then there is a question about the small fish. I mean, we were talking about the major platforms. I mean, Facebook, Twitter, and Google. But the question is, what do you do with 99.9% of the other platforms, which are not really the Facebook, Twitter, and Googles of the world? And how are we going to impose the obligations on the small tech, so small tech companies? How are we going to go about this? So maybe Imran, you wanna start with the business model?
Sure. I mean, so one of the studies that we did, one of our very first study of the anti-vaccine industry showed that we quantified the monetizable value of that attention to the platforms. And I built the economic. And my background is actually banking. I started at Merrill Lynch 20 years ago, and we built an economic model for it and calculated it was $1 billion. And I always play this trick when I'm doing these economic models. I always make the most conservative assumptions possible because I want them to say that's not true. And then I'll say, well, what is the real number then? Could you please explain to the select committee what it is? Because we know it's more than $1 billion a year for the attention generated and the advertising, therefore, that can be served up on the content generated by the anti-vaccine industry. Think about the anti-Semitism industry, the sheer number of people that are producing content that is monetized daily by those platforms, and they serve ads up to traffic regardless of what it is. So we are talking about hundreds of millions of dollars a year, and those profits are addictive because they accrue, don't they? So there's that one element, and I mean, getting some economic analysis beyond that is going to be very difficult. We've had to make a lot of assumptions in that modeling by necessity because they are not transparent. Yeah, so that's it from me.
Yes. Who wants to address the small companies? And also, I see a question on closed platforms and what can we do about I guess closed groups which are less accessible and and I guess a lot of the anti-Semitism and hate speech takes place there. Marianne, do you want to take a?
Yeah, that question about the small platforms comes up a lot. And I think it's important to think about it in a couple different ways. And the framework, I guess, I always want to urge is to think about offline analogies. That, you know, if we're sticking with, let's take an example of a car manufacturer, right? And that you are not a major car manufacturer, you're a tiny little startup and you've got great ideas for cars. And if you have to obey all the safety regulations that are placed on big car companies, like you have to have seat belts and airbags, that's just going to be so hard for you. And how will you compete? I hope that our answer would be, well, then you don't get to compete, right? If there's minimal standards that we think you should have to engage in, if you want to produce a potentially dangerous service or product, you have to meet those. And if you can't, you shouldn't be in this business. But we should also think about the fact that the smaller companies are also not going to have the same scale of problem, right? Facebook is going to be facing massive violations because they have massive amounts of content. And it speaks to the idea that a small company that's doing very small business isn't going to have the same potential for harm. But this is back to saying we need to be deciding on standards that are justified on their own merits, not because, oh, you have a lot of money, therefore you should do this. No, we have basic safety standards. We have basic expectations from industries that have been worked out over time, and they're not always going to be perfect. They're going to mean that some, legitimate or meritorious businesses might not make the cut. But if we decide that there are certain standards that are non-negotiable, we should stick to those no matter who is trying to come to the table. And if we want to encourage more innovation in small business, we can do that in the same ways that we've done that in the offline world. And if we're looking, because I expect that one objection will be to say, well, it's, car manufacturers and seatbelts are easier than deciding things like speech-related harms. Think about civil rights law. Think about the responsibilities of employers if there's sexual harassment or racial discrimination going on in their businesses. They have to take responsibility for that. You don't just get to say, I'm too small to do it. There are some minimal caps in Title VII and Title IX, but mostly you don't get out of saying you have obligations to respect people's civil rights just because you're small. And the same thing is also true on the disability front, right? Accommodations to some extent can be geared towards the size of your business or your entity. There can be other features that we might take into account, but it doesn't get you out of the game by saying, I happen to be smaller than these other companies.
Great. David, do you want to add something? Maybe also the closed groups issue?
Yeah, I mean, just a small point, although reflecting kind of a bigger problem or bigger issue with respect to the nature of this economy, which is the smaller platforms, as we've seen over the last, we've really seen this since Charlottesville, the hateful anti-Semitic neo-Nazi march in Charlottesville that, ended up with the killing of Heather Heyer by a neo-Nazi, right? And so after that, one of the major players at the infrastructure level, Cloudflare, which actually provides security to many platforms, to many websites around the world, it decided that it would kick off, it would no longer protect the Daily Stormer, a neo-Nazi, or we could just say Nazi website. And what that reflects, because we saw this also after the violence, the insurrection on January 6th here in the United States, was that there are a number of different actors, not just the platforms, who perform these kind of gatekeeping roles for the smaller platforms too, whether it's 8chan or Parler or Gab, whatever it is. And I do think certainly there's a role for government regulation to say there need to be standards. But in the interim, before we get to that point, because legislation is slow, clearly, the infrastructure companies themselves need to have standards and say, if you don't have a content moderation policy that deals with the rampant spread of hate and violence on your platform, we're not going to host you, or we're not going to provide you with the kind of security that'll keep you up and operating. Now, that's difficult because that's putting more and more power into private actors' hands. But I'm not sure I see a kind of another option for at least for the current moment when it's basically lawless when it comes to the public regulation side.
Right, thank you. And inadvertently, you also answered one of the further questions down my list on whether we really want businesses to make these sort of judgments. Let me throw probably the last couple of questions in your direction. One question is about accomplice liability. I mean, to what extent has this been explored and applied vis-a-vis platform liability? And secondly, there is a question about trustworthy and non-trustworthy sources, and to what extent do we see a potential in actually applying this distinction with respect to managing online contents? So who wants to have a go at one or two of these issues?
I'm happy to talk about the accomplice liability part of it because it reinforces something that I made reference to before, which is that collective responsibility idea, whether that's accomplice liability or whether it's vicarious liability, the framework that happens to control in most situations that are not online is, who is responsible for a harm, whether intentionally, unintentionally, negligently. We have all kinds of frameworks that we could develop for that. What I'm really concerned about in terms of the Section 230 issue is that it's so preemptive that it keeps those questions from ever getting asked. And the reason why we don't know how accomplice liability works online is because that question has been effectively short-circuited by Section 230. Companies invoke it, they get it kicked out at the really preliminary stages of litigation. We don't get discovery, we don't get hard conversations. They simply get to raise that as a preemptive defense. And so we've lost 20 years worth of time where we could have been developing principles of how accomplice liability, collective responsibility, civil rights responsibilities work out in these spaces. And so I think that's a big part of the problem. It's why I keep saying that, you know, one of the things that will have to be addressed, at least in the United States, and unfortunately in terms of being exported to the world, is this sense of preemptive immunity. You can't even ask that question.
Right. Imran.
Yeah, I mean, I profoundly agree. And I mean, look, I think that this is a multi-stage process that we're going to, and I agree with Marianne that we will need ultimately the power of the state to intervene in shaping the way that this comes out. It can't just be a program or social action. We can't literally ask the victims to fix the problem. And that sometimes we need the government as the voice of the people to step in. And I think there's two areas which are clear to me: that transparency, which is a pretty universally accepted thing. And that includes on things like where Google ads appear. So the way that their display network currently monetizes sites that produce vast amounts of hateful content or misinformation content. Google is one of the worst offenders of them all. But the second thing is the duty of care model. And I mean, what Marianne's describing there is something that the UK has been exploring, with essentially taking our health and safety law, duty of care concepts and that, transporting them directly to the management of the negative externalities of an industry that we know is good. I mean, social media in the last year has proven itself to be incredibly valuable. In part, it's been so dangerous because it has been so valuable. We've all been on there expressing our vulnerabilities, sharing succor and love with each other. And in those moments, we've been exploited. There have been bad actors who are willing to exploit it. But the third thing that I think, you know, at the moment, there's a terrorist use of the internet is something that we study at state level. And there's someone in the White House, for example, who does TUI for, he was a secondee from the State Department for a while. But we do need to have better understanding and use the convening power of the state to understand malignant actors' use of the internet. So that's across a whole array of different areas. And I think starting to see a more concerted understanding of how malignant actors use the internet. And then that will help us to understand, well, where are the critical junctures that we could intervene to disrupt that activity?
David, some concluding thoughts before passing it back to Ken?
These were really great final comments. I would just, on the trustworthy sources part of the question, I think that we really need to, first of all, address all of the harms that we've been talking about, but we also need to ensure that we are very much involved in working with legislators and policymakers to ensure that the definitions, because when it comes to disinformation or hate or other terms that we're talking about, they don't really have definition in law. We really need to create definitions that are workable and that can be adopted as a matter of law and then imposed on or applied by the platforms.
Great. So from my side, I want to thank all three of you for excellent interventions and very good and quick on your feet responses to a very diverse and difficult host of questions. And to you, Ken, I want to thank you again for inviting all of us. And I turn back to you now to wrap it up.
Thanks so much on behalf of Berkeley Law, the Diller Institute for Jewish Law and Israel Studies, and the Berkeley Center for Law and Technology. Thank you all for coming, and a really deep thanks to Yuval, to Imran, to Marianne, to David. I'll remind folks in the audience of MCLE credit. You can get the link in the chat. And I also want to note that the program is recorded and will be available on the website and symposium page soon. Thanks so much, and we hope to see you soon.